what is the cleaned up movement? And why don't you share with Tim in particular what that's about?
You mean sell?
That's right. I read between the lines. Maybe you have a nice friendly argument over this. So cleaned up it's actually an interesting phenomenon separate and apart from the merits, because it's a rare time there's been really any reform in the profession, that happened fairly quickly. So cleaned up is something dreamed up by an attorney here in Washington. And he was trying to do something about the whole blue booking apparatus that people tend not to like multiple reporters and having to have, citations omitted and quotations omitted and bracketing things that you lowercase. So the idea was you'd get rid of a lot of that junk. And then in exchange for that, at the end of the citation in parentheses, you'd put cleaned up. So it's taken off. Remember Justice Thomas did it, and that was kind of news. Another justice did it shortly thereafter. But when I say that the reform has taken off, as with every single thing in this profession, 24 hours a day, it's still controversial. And there are also people who hate it, right? I've heard three camps. I love it, I hate it, or I've never heard of it. It's still a fairly large group. So yeah, we'll see. I mean, the anti-case that I've heard is actually, I think, valuable to consider. And it's that, things that sound really obsessive compulsive, like bracketing, lowercasing, and capitalizing, actually are not. So if you're quoting from an opinion and it looks like you're quoting the whole sentence, but you're really not, that's something a lot of courts want to know. They want to see the bracket to see that it wasn't actually the beginning of a sentence.
Interesting. I've heard a fourth camp that sometimes, some people say it's okay for judges to use cleaned up because they're a judge would never miscite a case. But for parties, on the other hand, or lawyers representing parties, it's a risky move to do cleaned up.
That's interesting. I mean, I'm generally concerned about that just because I think judges do send cues to litigators and appellate advocates through their opinions. So if, they can't have it both ways, right? They can't do it and then say they object to it in briefs. I mean, they shouldn't think that's going to work, although intellectually I see the point. I mean, a lot of judges do get reversed, right? So I'm not sure they're all as pure and perfect as I know you have to say publicly. But yeah, there's something to that. I suppose there's something to that, right? That you're less likely, just given the clerks and the kind of the apparatus in the courthouse, you're less likely to really miscite a case, perhaps.